Hey everyone. So this is regarding the virtual hearings of these alleged public courts. The bottom line is, if it has not been clear to anyone up to this point that these proceedings are just private little get together, little huddle ups as to how they just want to make things appear in the public. Meaning it's just a private meeting that they have in here. And these Zoom meetings let you know very obviously that there's more going on than what meets the eyes. And people have to nip this in the butt. It has to be nipped in the butt. Or else it's going to turn into a slow walk to a point where the most basic things that you ought to be able to enforce will be made into a headache. That's not necessary. And unbeknownst to many people, if you pay a close attention to how these court dates go, they just call one case after the other. They have you consent to an appearance by doing a verbal notice of appearance. They ask you, defendant, state your name, this and that, you do that, and then they say, counsel, state your name, state the name, and then they just go through a motion as though behind closed doors they've already decided, hey, this is what's going to happen. Once we get to this date and time, let's just go through the motions and whatnot. The other parties, the everyday people who got a traffic ticket, is coming there because their houses is being taken from them. This is serious to them. But to the actors, they're just giving an appearance of something that really doesn't exist. And these Zoom meetings are making it worse because they will mute you. They will stop you from going into these quote unquote courtrooms. And they will basically infringing your substantive right. If you've yet to deny allegations that you're not employees of the municipalities that wrote you the ticket, is bringing claims against you, then you need to be doing that. Because the presumption is the fact that you belong to them so they can treat you that way. And so when you come into their private meetings, you have to fall in line because you're an employee. It's that simple. So get rid of that presumption. Deny that presumption. And then another presumption that exists is these Zoom conference hearings for these alleged public courts take place as a result of general administrative orders that's passed in each county by the chief judge. And these general administrative orders basically let you know, look, this Zoom hearing, we require your consent to it. It is not mandatory. You don't have to come here and do this. We need your consent to do it. And given the fact that they are presuming that you are their property, to say an employee is just a fancy modern day word for saying you're a property of someone else. Since the presumption is you're their property and they can treat you how they want because they do that. The presumption is these general administrative orders apply to you by default. And even when it applies to you, they still require your consent. And you have to waive that substantive right. And your constitutionally secured right cannot be waived unconsciously or without your knowledge. There's a maxim of law that says an act done without me is not mine. But why wait for the future to bring all that up when you can just get it done? So it's important for you to remove the presumption by putting an affidavit right from the start based on the Constitution that you do not consent. Whatever you want to title it, you title it the way it makes you feel comfortable. The way that your spirit flows and enforce things in a beneficial manner to you and in a reasonable and fair and equitable manner to you, you do that. if it's as simple as an affidavit not consenting to Zoom hearing or teleconference hearing. In accordance to what? In accordance to three very simple principles. The first one is due process. Your right to petition, your right to grievance, your right to be heard. All those things are really categorized under due process. So find your state constitution, look into the due process clause, and these due process clauses affirmed by your right to apply for redress and grievance. In Illinois, it makes it very vague, but in Minnesota, it tells you straight up that, I think it's in Article 13. There it is right there. The governor, secretary of state, the treasurer, auditor, attorney general, and the judges. Basically all the people, all these people that make the average man and woman shake, increase their heartbeat, and people go out of their mind when they get letter headings from these offices. They're letting you know that all these people may be impeached for corrupt conduct in the office or for crimes and misdemeanor, but judgments in such cases shall not extend to further than to remove from office and disqualification to hold and to enjoy any office and honor, trust, or profit in this state. Meaning it's telling you that you can impeach them so long as they are holding these capacities: position of trust, profit, or any office. If they're not in honor of it, you can impeach them. Anything else is in their personal capacity. So it's letting you know that these parties, the governor, secretary of state, treasurer, auditor, attorney general, the judges of Supreme Court and district courts, are in a trust position. If the preamble doesn't tell you straight up, there's going to be a specific portion that tells you. Impeachment just means, just think of it as a seat, and the seat has the position, it has words trust, profit, or state attached to that seat. Someone wrote it on a piece of paper and taped it on that seat. To impeach them is to tip that seat forward and have them fall. So they are in a position of trust, and your substantive right to grievance and redress is based on you, the one who granted that ability. And if you say due process is not afforded by these Zoom conferences, for many reasons. One, you don't have to consent to it. Two, technological issues. A lot of people are not savvy to how to use technology. And because of that, you're just going to railroad someone and just say, hey, defendant, are you here? They're not here. Okay, well, let's do a ex parte judgment. Or, well, create an order saying they were not present. So they abandoned and waived their substantive right. And you can literally destroy someone's life just like that. It's really just that simple. Why? Because someone is trying to find out what the password to the Zoom case is. Why? Because someone did not know they have to go to the App Store or how to download something. Why? Because they don't know how to function, define the internet connection. Some people have never even used a computer the way the everyday new generation does. And even if it's involved in a minor situation, who's to say that computer technicality cannot occur that same day? And someone's whole life is just going to be destroyed by some virtual hearing. And even if they do go into that virtual hearing, the internet connection can cut off. The audio might malfunction. The intent might not be sent out properly. Just like any law, when it's created or when a crime is committed, the intent is looked at. Well, the same thing applies with your everyday proceedings in any public court. If your intent cannot be sent across properly through your verbal judicial notices because the audio is cutting off because of the speed rate of your internet, or because something, whatever happens, now you're delaying everyone else who is online in that conference call. And even worse, you get abrogated upon because some municipal employee does not have the patience. They just cut you off, or worse, they mute you because you're enforcing your constitutionally secured right. Chapter 19 also tells you, subsection 19 tells you every person ought to find a certain remedy. Whatever this certain remedy is, you make that determination. If the remedy is you challenging the constitutionality of the matter, the personal subject matter jurisdiction as a result of that, if this remedy is because you're trying to seek a remedy that, hey, the complainant cannot also be the witness and cannot also be an officer of the court. Whatever your remedy is, you have the right. Ought is based on equity, meaning it should be known, and this is what should be done nonetheless. Every person ought to find a certain remedy in the law for all injuries or wrongs which he may receive in his person, property, or reputation. He ought to obtain by law, by right, and justice, freely without being obliged to purchase it. But this is where the whole fee waiver thing comes from. For those of you who want to, waive court fees, completely and without denial, promptly and without delay. The Zoom hearings create a lot of delay because they put you in holding rooms, and sometimes they don't even allow you to go in promptly, in the sense that it is delayed. If there's a technological malfunction, if there's somebody constantly muting you, it's not prompt. You're being denied due process. You're being denied your remedy, affirmed by law, right, justice, and equity. Put your state constitution to use. Deny the fact that you don't belong to that municipality is bringing the charge, so that you will not be construed as though they can do whatever they can with you. And bring up these executive orders. This administrative rules. For instance, and here it tells you, all pleas for misdemeanor cases on Zoom will require the defendant's signature on the waiver of defendant's right to be physically present in court, jury waiver, sentencing order, and assessments of fines and fees. Meaning, what all this is saying is they need your written consent for you to waive your right to be physically present. Meaning the presumption already exists that, hey, look, you have these rights, but if you don't know about it, you can waive it. And guess what? Since they created this rule, they can always modify it in the future, or as they go, and just ask you for your consent just by you stating your name as a notice of appearance. That can be construed as a consent, that you're waiving your right to be physically present. And we know, even though it says here misdemeanor, and they say that they deal with felony cases and traffic matters, but we also know that these municipal courts are quasi. They show you in the face of their instruments. The Circuit Court of Cook County, Illinois, and right in small print, I had to zoom this in extremely, 200 times? 200 times. Just so this little fine print underneath says criminal or quasi. If there was no possibility of them engaging in quasi situations, they would not put this option over here. So they're letting you know that you can't say they're not telling you, but they put it in small print, of course, like they do with the checks and whatnot. They're putting it right here. So now when you challenge this and you ask him, is this criminal or quasi, the good old stuff people usually ask, they know for a fact that it's this. So if they're telling you that this only applies to just misdemeanor, then surely applies to everything else, because everything they're doing to begin with is just a simulation of legal process. It's just vexatious litigation. Speak about it. Don't stay silent about that which ought not to be silent about, because they will railroad you. If you're on a federal level, it says the same thing basically. Rule 43, your presence. When required. Unless Rule 5 or Rule 10 provides otherwise, defendants must be present. What we're looking for is B. But when you're not required, a defendant need not be present under any of the following circumstance. If you're dealing with misdemeanor, if the offense is punishable by fine or by imprisonment, which most of the time it is, for not more than 1 year, or both, and with defendant's written consent. There it is again. And meaning not just any of these, but with the inclusion of this. Meaning if all these criteria are involved and this is not there, then it's no. So your written consent is required for you not to be present. Defendant's presence when not required. Your written consent is required. Their arraignment, which is when they want to ask you, hey, do you plead guilty or not? And this is the charges we brought against you. When you plead, when you enter into contracts, which you probably shouldn't, because you'd be setting yourself up for failure right off the bat. At trial, which is when they test the sufficiency of all their administrative process they've done on you, or when they just go through the motions to screw you up. And sentencing, which comes right after that. So basically all the court proceedings. And of course before trial they have voir dire, which is the jury selection and whatnot, and all the other subtleties in between. But ultimately they need your written consent. Now this is the Federal Rules of Criminal Procedure. Now you're saying, okay, criminal procedure. What about civil matter? Good question. One form of action exists, and that is all civil. It's all based on contract. It's all based on your consent. That is why it has to be written down. For certain things to occur. If there's no civil action involved in even criminal matters, they probably wouldn't need to write things down. When you begin to preserve records, you get into things regarding contracts and trust positions. You can use this as admissible evidence because this right here is issued by the U.S. courts. Okay, we're back. Now, back to Illinois or your states. The same requirement for consent, according to constitutional principles, are also preserved. The general administrative orders that they issue is usually according to here in Illinois, it's according to the Supreme Court rules. And where they derive their ability or what they create the administrative orders in accordance with is Rule 45. Of the Supreme Court rules. So this is the Illinois court website. Tells you the court may upon requests or in its own order, and if in order for this order to be created, it has to be reasonable and constitutional. The court may upon request or in its own order allow a case participant to participate in a civil or criminal matter remotely. That is the Zoom that they use. Including by telephone or video conference. That is the Zoom that they use. Use of telephones or video conferences, the Zoom that they use, in criminal or juvenile delinquency matters shall be undertaken consistent with constitutional guarantees applicable to such proceedings. And what are these constitutional guarantees applicable to such proceedings? These criminal and civil matters, these quasi-criminals matters. Everything within the Bill of Rights in the preamble. More specifically, if you're in Illinois or any other states, anything dealing with due process, substantive right to apply for redress and grievance, and your right to find certain remedies. Might be as simple as to dismiss the case for the reasons herein, promptly and without delay. So long as you can prove that those Zoom hearing is delaying your due process, it's denying you the ability to enforce your substantive right to redress of grievance, and this is null and void, because this stands on this. And if this trumps this, the Constitution trumps any rules, any general administrative order. They're not hiding it from you. They're letting you know this is an administrative proceeding that they're privately engaging in. They tell you. GOA here stands for General Administrative Orders. So if we go to page 4 and we look at section 3. That's a further order of the court at the discretion of the judge presiding, meaning whoever is hearing the case, and upon the defendant's execution and it's an inclusion, not one or the other, upon the defendant's execution of a waiver of physical presence. Bench trials may be held in person, by video conference, by telephone, or a combination of those matters. The most important thing is that they require your consent. It is not the responsibility of the whatever government it is. It's not their responsibility to stop you from falling into error. It is your responsibility to stop them from falling into error. Many steer decisis on that, because the power really lies in your hand. And the reasonable expectation to meet the whole face mask, because the whole reason why they're claiming to be doing this whole Zoom thing is because they're saying, well, for the public safety, they always use that word for the purpose of the public, or the safety of the public. So there's an emergency. And that emergency itself is even open to constitutional challenge, because that emergency is executed not by the legislative department that creates laws. It's created by executive, it's actually enforced by the executive department. And that executive department order, the COVID order to wear face masks or stay 6 feet apart, and if you can't stay 6 feet apart, then wear some face covering and all that. That executive order only applies to the executive department. It's that simple. The only circumstance where a mandate can be issued and applies to everyone, that everyone is obligated to follow it, is if it's based on the legislative department, the General Assembly. And even if it's ratified and passed by the House, the Senate, and all that of whatever state you're in, it's still open to constitutional challenge. And in Illinois, what they do is they issue the executive order over and over and over. And when they issue it over and over, they amend it and add modifications to it. So that's how they add more requirements. But the basics is simple: 6 feet apart or wear a face mask. And the only reason why they can keep amending it to add different phases to reopen and all that is because of a separate statute here at Illinois that pretty much says the governor is able to renew emergency orders after a certain period of time. So they use that as a loophole to constantly keep issuing newer and newer executive orders regarding the whole alleged emergency. But the interesting part about that here is the previous Attorney General, prior to the newer one, Kwame Raoul, the previous Attorney General, Lisa Madigan, makes it very clear in her memorandum that executive orders do not really apply to everyone, and it only applies to people in the executive department. And the power granted by the statute that allows the governor to repeatedly issue these mandates, whatever the mandate is, that power does not allow the governor to create new laws, because the governor does not have the ability to create new laws. Just the basic principle of how government works: judicial, legislative, executive. The legislative creates the law. The mandate was released back in 2013 by the previous Attorney General, Lisa Madigan. This is admissible evidence if you know how to use it. Applicability of executive orders. It's as though they saw this coming long ago and they just put it out there for those who are willing to find, who are willing to seek. Let's go to the important part. It goes, the Constitution provides that the governor, by executive order, may reassign functions among or reorganize executive agencies. Executive agencies, which are directly responsible to him. This is the only reference to executive orders in the Constitution. This is the only reference to executive order in the Constitution. And as a result, the only circumstance in which an executive order clearly carries the force and effect of law. An executive order in Illinois from the executive department issued by the governor only carries the force and effect of law. Force as in it's only enforceable. Effect means it only applies to people, certain people, if and when under the circumstance that the functions are amongst or is involved with the executive agencies, which directly is responsible to the governor. It tells you right here. It's right here. Beyond the common sense of how government works, there's a memorandum out here that tells you, look, these executive orders only applies to people within the executive agencies and people directly under the governor. It then goes on to say, in general, besides the specific section of the Illinois Constitution, the governor shall have the supreme executive power and shall be responsible for the faithful execution of laws. Citing his authority, the Illinois courts have suggested that an executive order may be a permissible method, permissible, to permission, by which the governor can execute an existing law. But that an executive order is not a vehicle to establish a new legal requirement. Executive orders cannot create laws because the governor does not have that power. That's where the concept of separation of power comes in. Executive orders can only be used to enforce existing laws. That only applies to executive agencies directly under or directly responsible to the governor. Simple as that. Accordingly, the governor does not have power to legislate by executive order, and therefore, unless authorized by law, an executive order relating to matters other than executive organization can be no more than a policy directive to agencies under the governor's control. To conclude otherwise will cede to the governor legislative power which he is prohibited from exercising by the separation of power doctrine. It's self-explanatory. Very simple. So all these general administrative orders, remember we were talking about denying that you're an employee of the municipalities that arrested you and all that, whatever it is, or that's bringing a claim against you. All these things only apply to the employees of the court. Deny that. Make that very clear. Who knows? There might be an equivalence of this in your state. Look for it. Find it. I guarantee you it is out there. Just do the research. You will find it. And even if you don't find this, you have sufficient power. This alone is more than enough to kick their asses. All you need is just the Constitution. And if you're in a federal court, bring up the United States Constitution. And the good part is most federal courts have concurrent jurisdiction with state jurisdictions, state laws. So bring this in also. Don't limit yourself. You actually have the power. So when you get a ticket, when you're dealing with anything in public court, if it's been dragging on 2-3 years, if it's just occurred, deny the allegation that you're an employee of whoever's bringing a claim or that court that's creating these administrative orders issued by the chief judge. And then simply do your own affidavit based on the state constitution that you do not consent to these hearings. And then make reference to the specific portions of whatever that court's general administrative order is that says, hey, according to your words, you require my consent. And they never bring this up. Never, ever. They never bring this up. Can you imagine about 80, 90 people on a Zoom call at 9 o'clock in the morning and they got to get done by 12 and they go to recess once and then they come back at 1:30 and do all the other private stuff when there's less people in the afternoon? Can you imagine asking everybody if they consent to the shit? They're not going to do that. But then again, they're not obligated to disclose this to you because it's a general administrative order. They're just running their private trust. So you bring the proper one in and enforce it. And also, as an adage with the federal jurisdiction, it would be good to also bring in the Articles of Confederation because it validates the creation of that federal constitution. And the loophole that I was referring to regarding the executive order whereby they constantly just keep amending it over and over beyond the 30-day limit is in Section 7 of the Emergency Management Agency Act. Of course, you know, the agency administrative stuff. It's in Section 7. It says emergency powers of the governor. In the event of a disaster, as defined in Section 4, the governor may by proclamation, which is the executive orders, declare that a disaster exists, which is the alleged, COVID-19 stuff. Upon such proclamation, the governor shall have and may exercise for a period not to exceed 30 days the following emergency powers. So 30 days is a limitation of their ability, or shall I say 30 days is a limitation of the effect of these emergency proclamations. But nowhere within these acts does it stipulates whether it can be renewed or amended, and whether when it's amended or upon amendment, whether this 30 days renews or not. And that is the loophole.